When it comes to the laws that govern how law enforcement and CSIS gathers information, Canada is woefully behind most of our allies. Our laws are stuck in another century while technology has moved forward. Criminals know this and they take advantage of it every single day. They use many of the same digital tools that are in our pockets and on our desks, but they use them for human trafficking, online sexual abuse, extortion, child exploitation, fraud, and many other crimes. And these criminals are organized, and often they are across borders or continents, and their crimes can be transnational. The tools we have to fight them are inadequate to the task at hand. And that's why yesterday our government introduced Bill C-22, an act respecting lawful access. C-22 creates the legal framework for a modernized lawful access regime in Canada, something that law enforcement and our security services have been asking for decades. This new bill is informed by the former Bill C-2, but its provisions are different. The Act respecting lawful access, informed by views from stakeholders and parliamentarians who voiced serious concerns with the former bill. We listened to what they said, and this new legislation, C-22, balances the need for law enforcement with the privacy rights of Canadians. I want to be clear about what C-22 is not. It is not about surveillance of honest, hardworking Canadians going about their daily lives. It is about keeping Canadians safe and catching criminals. It ensures that law enforcement can obtain timely, lawfully authorized information when they need it. It aims to create a consistent and clear legal framework for service providers to allow them to comply with existing legal orders. And it brings our laws in line with the Supreme Court rulings to make clear that law enforcement and CSIS can receive tips, ask for information to be provided voluntarily, or use publicly available information to investigate crime and threats to our security. So Bill C-22 is a package of targeted reforms that tackles the world as it is, not as it once was. The bill builds on the work that we're doing in other legislation to combat hate, eradicate gender-based and intimate partner violence, and make bail stricter and sentences tougher. On the bail and sentencing reform legislation, I want to mention that while it is extremely important legislation, but it only comes after law enforcement has successfully investigated and made arrests and laid charges. In Peel, we are all too familiar with violent cases of extortion and human trafficking. And this new bill will give law enforcement the tools they need to better and more quickly investigate these cases so that they can make arrests and lay charges.
It's good to see that government is giving tools, safety tools, step by step to our law enforcement. Good to see that. Earlier it was FinTrack and now Bill C-22. But criminals move one step ahead. So now they use the technology VoIP, Voice over Internet Protocol, and Telegram chats. Does this bill address the issues of web browsing, VoIP issues, because extortion calls from VoIP calls, they were not traceable, social media history, AI chat box, because we saw the incidents in BC, Tumbler Ridge tragedy. And also, why can't this such important safety measure get a consensus support from all the political parties? It's a very important bill. Thank you.
Yeah, I'll start with the last part of your question. It's absolutely why we're here today, making this announcement so that Canadians can understand the importance of this legislation and how it would help victims of crime. The purpose of this this legislation is faster identification. The police is obviously right now operating within a system that does not provide them timely information. There's not a proper structure in place with telecom companies and social media companies, which are captured by this piece of legislation. There are some telecom companies that are specifically identified that will immediately have to implement a system in place to be able to provide access to law enforcement when judicially authorized or when confirmation of service is needed. However, as social media companies continue to expand, like we've seen over the years, it also provides the authorization and ability for a governor and council order to be presented, and it gives the Minister of Public Safety also the power to impose a structure upon a social media company. This is also about cooperation, this bill, right? So we are trying to make sure that nationally, domestically, internally, we can cooperate better within a system with our companies here in Canada, but also abroad. So it gives the federal government the ability to better cooperate and negotiate when those social media companies are housed in the U.S. or other countries. So thank you for your question.
Thank you.
Is there
Chief, you want to add on this AI chat box and the other web browsing and other tools?
Yeah, thanks, Nitin. And to reinforce what Secretary Sahota had indicated, is that at current, very simply, if I was to receive a threat on WhatsApp or social media, we have to obtain a judicial authorization to find out the source. And so some of that is the timeliness of it. If we were to able to even find the provider of where the phone number came from, we might have to wait up to 30, 40 days to get that. And if you can imagine if it was a threat or an extortion or a shooting, in that period of time, the amount of victimization is absolutely compounded. It continues. The same perpetrator conceptually could be going to other people and victimizing them. So yes, you can name any digital platform. What this allows us to do is to not only determine who the service provider is in a timely manner, it allows us to obtain the information. Many of the providers aren't even on Canadian soil. For example, they're in the US or abroad. It allows us to, previously the regime that we had to do was have mutual aid agreements to have information voluntarily passed to us. Previously, if you were an entity that had the data and you wanted to just voluntarily give it to us, we still needed authorization to do that. So it is a very multifaceted bill that has a lot of depth to it, but in every element, it makes it, to the Secretary's statement, is that it's built on cooperation, it's all judicially authorized, but it compels the systems to operate in a far quicker manner. And that, I can tell you right away, this is deeply intertwined to everything, every issue that we see here in Peel, in Canadian policing, period. So the answer is a yes to everything you asked for. Yeah.
We have the self-defense laws since a long time, and there is a terminology used as a reasonable force, which was a point of discussion across the globe. Like there is a question on the reasonable force. Can you commit Canadians that if any homeowner won't be charged if armed intruders enter their property? Because that's a concern with many of the Canadians across Canada, that midnight home invasions, that with the armed intruders and homeowners were charged, even though we had the self-defense laws. So can you commit, and what is the solution for this self-defense? Thank you.
Yeah. So first off, I would start by saying that self-defense is a defense in Canada. It exists. Regardless of the information and a lot of the conversations that have been happening, that people that have been coming up to me, there has become an understanding or a belief that people are not allowed to defend themselves in Canada. It is well established that you can defend yourself in Canada. What the level of force that is used in order to defend yourself is what can be at question. So, your question, I think, is, one for perhaps even law enforcement in some ways, because every case is different, and it depends on when an officer comes to the scene and what may have happened in those circumstances. So if somebody, for example, is murdered at somebody's residence, there should be an investigation at that murder scene. And to say that there should be no investigation and nobody should have the ability to lay charges, I think would go too far within the Canadian system. And even those that say that the U.S. has such laws, that does not exist across the U.S. as well. And in the states that it does, they have seen incidents where innocent victims, people who are, mistakenly going to the wrong house to pick up their little brother. There have been many cases that I could list that I've looked into, and we don't want to create a system where people feel that they have the right to shoot and kill somebody. So I understand the sentiment that is behind a lot of these comments. And I think the sentiment is that people want to be safe in their homes. And that's exactly what we're trying to do through the series of different pieces of legislation we're putting forward to try to give law enforcement the tools that they need to make sure that investigations can take place swiftly, efficiently, and that stiffer sentences are also imposed on those individuals that commit crimes. We want to deter them, we want to catch them, and we want to punish them. And that's achieved through all the different pieces of legislation that we've put forward. We want to make sure that Canadians feel safe at the end of the day. And so that's what I would say, that, people do have the right to self-defense. And that law was updated it was updated quite recently, I believe in 2014 or 13. And so, the piece of legislation that we're talking about today, the last time we saw an update was 30 years ago. And I think it's really crucial that we make sure that police have the tools they need, to investigate crimes. And these crimes do include break-and-enters, auto theft, murders. You name it, lawful access would be able to provide police the tools needed to efficiently investigate those crimes and hold perpetrators accountable.
Chief, you want to add on the self-defense, if you want to see any changes in the self-defense from the home intruders?
So, sorry, Nin, I can't speak on behalf of the federal government, and clearly today is about Bill C-22. You and I can speak every day of the week on these other issues. So I don't know if it's the most appropriate time to talk about self-defense, to be honest. But we at Peel understand people's fear of being victimized in their home. Their homes are now, people are concerned to leave their children at home at night when they go out. And it's absolutely an issue, obviously. And our wholehearted focus is on what can we do to turn the dial down on that. We have spent time with Minister Fraser, Mr. Anand Sangri on ideas to get upstream to prevent this from happening. In fact, even like the suggestion of new offenses as it relates to home invasions and those type of things. So, and our efforts are always on how do we prevent it before it always happens. Absolutely, yes. Do people feel concerned about their homes? But be happy to talk to you offline on that. And
if I may, I'll say one more thing to that. One of the incidents that recently happened that has really, I believe, sparked this conversation. I believe it was that Ontario man that was charged after a home invasion, and there was a kerfuffle, a fight, whatever happened in that scene. There were charges laid upon the homeowner. Those charges have since been dropped. And I think that is recognition that when the system looks at the facts of the case, when they're able to identify what occurred, that the system does work. And so if you go and look up that case, it did not go to proceed to trial on charges laid against that homeowner. So I feel Canadians should feel rest assured that, once again, self-defense does exist, and the police and through Crown prosecutors, they're able to, after looking at the facts of the case, identify the proper outcome that needs to be achieved. And I'll go back to, Bill C-14 again addresses break-and-enters, repeat violent offenders, to be able to deter and give harsher penalties and make bail more difficult to receive in those cases.
So, Chief, what you'll say about this Bill C-22? How confident you are that this will make an impact?
Absolutely. The police sector fully supports the introduction of this bill. It is giving us the ability to investigate, respond, and get the evidence we need in a way that we've never been able to do. If you think about a crime scene where there's forensics, then people get fingerprints and whatnot. This is equally as critical for it. Can you imagine that we've never been able to do it? We'd have to get it, but it might take us a month, 2 months, 3 months, sometimes a very long time to be able to get information to be able to respond to it. So this is, we fully support the amendments and they will be a positive tool for us.
So the voice over internet protocols, the criminals, they use internet phones. Can that be traceable, or what to do, how to trace?
So the ability to investigate things like digital-based threats or crimes has always been there, but we've not been able to get the data in it. So that data has always been accessible, but we never had a framework to get it in the right timely manner, in a way that's we can cross international boundaries. We can work with the electronic service providers to be able to get the data in a manner that is acceptable to them, but also timely for us. Those things never happen, and so this is very good for us.
So artificial intelligence is playing a big role, and criminals are also using that. Is anything mentioned in this bill, like that we can get information or working with the AI to get an information, and so that is also one of the biggest tools we can have.
So if you look at all those platforms like artificial intelligence, voice over IP, even social media, when you go behind the scenes, there's always a digital footprint. We need the digital footprint, and this allows us to be able to go to the service providers, identify who the right one is, but in a timely manner, where that is the biggest thing, is the timeliness of it is critical. Because while you get a threat and you have to wait 2 months to hear from the police, it frustrates the public, frustrates us too, but we're able to now get it much quicker, and then we can find out who, investigate, and go determine who's responsible.
Okay, any message you want to give to the resident appeal?
Yeah, listen, I think that residents appeal need to know that on top of the national policing platform, we at Peel continue to advocate for the interests of our community, and this is one example of it. This is why they're here today.
Thank you, Chief.
Thank you, sir.
Thank you. Thank you.
You too.
So, Ruby, Bill C-22. So, it's good that government has addressed the privacy issues which was there in the Bill C-2. How this bill is different than Bill C-2?
So ਇਸ ਬਿੱਲ ਦੇ ਵਿੱਚ ਸਕੋਪ ਜਿਹੜਾ ਹੈਗਾ ਆ ਥੋੜਾ ਛੋਟਾ ਹੈਗਾ ਆ ਨੈਰੋ ਹੈਗਾ ਆ ਉਸ ਬਿੱਲ ਦੇ ਨਾਲੋਂ ਉਸ ਬਿੱਲ ਦੇ ਵਿੱਚ ਆਲਸੋ ਮੇਲ ਪ੍ਰੋਵੀਜ਼ਨ ਸੀਗੇ we'll see how we want to bring that back to ਕਿਉਂਕਿ ਉਹ ਵੀ ਜ਼ਰੂਰੀ ਹੈਗਾ ਆ
ਉਹਦੇ ਚ ਵਾਰੰਟਲੈਸ ਸੀਗਾ ਬਿੱਲ C-2 ਚ ਕਿ ਵਾਰੰਟ ਨਹੀਂ ਚਾਹੀਦਾ ਫॉर the access data.
No, that's not true. But mail lay provision siga mail search lay, and in this, jo lawful access the regime C2 de vich it wasn't warrantless, but it jo service providers sige oh changi tarah define nahi kite gaye sige, and jo information police mang sakdi sige went beyond confirmation. So you're right. So without the warrant, they could have the subscriber information as well, but we'd realized that there is a Supreme Court case on that. So is legislation de vich jedi confirmation hai of service provider bhi matlab oh information kis data kis company ਦੇ ਵਿੱਚ ਸਟੋਰ ਕੀਤੀ ਗਈ ਹੈਗੀ ਆ ਉਹਦੀ ਕਨਫਰਮੇਸ਼ਨ ਯੈਸ অর ਨੋ ਕਿ ਤੁਹਾਡੇ ਕੋਲ ਇਸ ਬੰਦੇ ਦੀ ਇਨਫੋਰਮੇਸ਼ਨ ਹੈਗੀ ਆ ਤੁਸੀਂ ਇਹਨਾਂ ਨੂੰ ਕੋਈ ਇੰਟਰਨੈਟ ਜਾਂ ਕੋਈ ਵੀ ਸਰਵਿਸ ਹੈਗਾ ਹੈ ਨਾ ਕੋਈ ਐਪਲੀਕੇਸ਼ਨ ਹੋ ਸਕਦਾ ਹੈਗਾ ਤੁਹਾਡਾ WhatsApp ਹੋ ਸਕਦਾ ਹੈਗਾ ਆ it could be Google and it could be our telecom companies here in Canada as well and ਕੀ ਉਹ ਤੁਹਾਡੇ ਕਲਾਇੰਟ ਹੈਗੇ ਨੇ ਕਿ ਨਹੀਂ ਹੈਗੇ that is the first step that can be done warrantless. Us to baad jo hega ya ek production order di load hegi subscriber information lay. So a production order is a little bit easier as well than a general warrant, and production order de naal thonu subscriber information mil sakdi hegi matlab name, address, And excuse me. Sorry. So, matlab name, address, phone number. If it, what phone number is connected to an IP address. Je phone number हैगा, then उसका IP address की हैगा, email. That type of जिमें police chief ने क्या हैगा, biographical type information. Right now, in emergency situations, also is bill ਦੇ ਵਿੱਚ identify ਕੀਤਾ ਜਾਂਦਾ ਹੈਗਾ जो kidnapping हो रही हैगी या there's a potential murder that could take place.
Child exploitation.
There's after a
Yes.
kidnapping that a child is in someone's possession, so immediate bodily threat ਜੇ ਹੈਗਾ या ਕਿਸੇ ਨੂੰ ਜਾਂ ਕੋਈ terrorist activity take place ਹੋਣ ਵਾਲੀ ਹੈਗੀ ਆ, then in those cases, yes, there is warrantless provisions, which right now police are allowed, but ਇਸ bill ਦੇ ਵਿੱਚ ਉਹਨੂੰ codify ਕੀਤਾ ਜਾਂਦਾ, ਜਾਨੀ clearly state ਕੀਤਾ ਜਾਂਦਾ ਵੀ ਇਸ areas ਦੇ ਵਿੱਚ police action ਇਹ information ਲੈ ਸਕਦੀ ਹੈਗੀ ਆ when there is a national emergency or human risk emergency.
ਜਿਹੜੇ ਵੌਇਸ ਓਵਰ ਇੰਟਰਨੈਟ ਪ੍ਰੋਟੋਕਾਲਸ ਹੈ ਕ੍ਰਿਮੀਨਲਸ ਅੱਜ ਕੱਲ੍ਹ ਉਹ ਨੈਟਵਰਕ ਯੂਜ਼ ਕਰ ਰਹੇ ਹੈ ਔਰ ਐਕਸਟੋਰਸ਼ਨ 'ਚ ਦੇਖਿਆ ਪੋਰਚੁਗਲ ਸਿੰਗਾਪੁਰ ਉੱਥੋਂ ਦੇ ਨੰਬਰਸ ਤੋਂ ਕਾਲਸ ਆਉਂਦੀਆਂ ਜਿਹੜੀਆਂ ਕਿ ਟ੍ਰੇਸ ਨਹੀਂ ਹੁੰਦੀਆਂ ਸੋ ਕੀ ਉਹ ਇਹਦੇ ਥਰੂ ਕੁਝ ਟੈਕਨੋਲੋਜੀ ਦੇ ਥਰੂ ਟ੍ਰੇਸ ਹੋ ਸਕਦੀਆਂ ਪੁਲਿਸ ਲਾਅ ਇਨਫੋਰਸਮੈਂਟ ਕਰ ਸਕਦੀ
That is the expectation and the hope. Jo another cyber security center हैगा या they have ways of tracing this. This is one piece that will help to identify क्योंकि they're still using a phone that is subscribed to some network, but ਉਹਨੂੰ ਲੁਕਾਉਣ ਦੀ encrypt ਕੀਤਾ ਜਾਂਦਾ ਹੈਗਾ ਉਹ evidence. So the police are telling us that this is what will help them with the beginning steps to get that information eventually.
Okay, so
and faster.
Yeah, so you across the Canada ਤੁਹਾਨੂੰ ਕ੍ਰਾਈਮ ਦੇ ਉੱਪਰ ਕਾਫੀ ਸਵਾਲ ਆਉਂਦੇ ਆ ਸੋ ਕੀ ਕਹਿਣਾ ਚਾਹੋਗੇ ਤੁਸੀਂ ਕੈਨੇਡੀਅਨਸ ਨੂੰ ਕਿ government is acting step by step giving all those safety tools to the law enforcement agar फिर भी crime control नहीं होता और how confident are you कि now we will control this crime with the tools government is giving to the law enforcement
देखो I think आने वाले टाइम ਦੇ ਵਿੱਚ कुछ extortion related भी announcements police ਵੰਨੀਆਂ ਹੋਣਗੀਆਂ जो groups organized crime groups is type of activity ਦੇ ਮਗਰ ਲੱਗੇ ਹੋਏ ਹੈਗੇ ਨੇ every time ਉਸ organized crime group ਦਾ ਨੂੰ disrupt ਕੀਤਾ ਜਾਂਦਾ arrest ਕੀਤੇ ਜਾਂਦੇ ਹੈਗੇ ਆ convictions ਹੁੰਦੀਆਂ ਹੈਗੀਆਂ it does have an impact on crime that is happening. So मैं पूरी confident हैगी हाँ that through the many different bills that we've put forward, भी ਇਹਦਾ एक positive impact होगा जो लोगों ਨੂੰ नजर भी आऊगा. It will help keep Canadians safe. Is it the only part of the puzzle? No. सिर्फ कानून only part नहीं हैगा. Our courts have to work the way they need to work. They can't just be charges ले police ने कर देते फिर court ने drop कर देते crown ने drop कर देते. वो भी important हैगा या piece हैगा या. So that's the provincial piece. That is important भी ਉਹ resourced अपने court system होवे so that ਉਹ इन्ना cases ਨੂੰ handle कर सके and जो सख्ती police ने दिखाई हैगी आ भी ਉਹਨੂੰ decrease करके ਉਹ charges ना court ਦੇ ਵਿੱਚ pursue ਕੀਤੀਆਂ ਜਾਣ ਪਰ full extent ਦੇ ਨਾਲ pursue ਕੀਤੀਆਂ ਜਾਣ that's an important part as well. Yeah.
Thank you, Ruby.
Thank you.
Absolutely, Nitin. I'm very excited by the announcement that was made today by Secretary Sahoda. This is part of the laundry list of asks that Peel Police, City of Brampton have been advocating for a very long time. And the last time we met in Ottawa with the ministers and their staff talking about the various issues and how we can tackle them, how the federal government can make meaningful changes to address some of these. Last month, we saw the announcement about FinTrack. Today, we're seeing this announcement about lawful access. Again, Peel Police has been advocating for this for a very long time to ensure that they have the best investigative tools to keep our residents, our community safe. So I'm very happy to see the quick turnaround from the time when these discussions started. But it is the best time to, see this legislation come into act and Peel Police having the right tools right now to ensure that they have all the resources that they need, all the different tools that they need, and tools that are relevant in 2026 to solve the new wave of crime that we're seeing happening in Canada.
The importance of Bill C-22 as presented yesterday in Ottawa means a lot for public safety, and particularly here in Peel, we have been a strong advocate for this alongside our policing partners. So at its core, this legislation ensures that the law reflects what has changed in modern policing and in all of your lives, to be frank. The legal framework speaks to our ability, obviously, to obtain data, search, and seize information in a way that, can I tell you, never existed. The legislation as it stands was in a pre-digital world. And those that are harming our communities right across this country are the ones that are taking advantage of the fact that we haven't had the tools to stop this. And so our ability to operate in a fully digital world is absolutely critical for public safety. And so the gaps in investigations, what the community is often frustrated, and many of you from the media, I appreciate you being here, often ask what can be done more. Today is actually an example of us seeing a bill being proposed in front of us that also allows us to do this. It does not overstep the elements of accountability. The core of it is lawful access that is judicially authorized, but allows us to achieve it in a better way. So can I tell you, here's a perfect example. The last legislation existed before Google even existed. It's 10 years behind when the first iPhone was ever introduced. And we are still operating on legislative authorities that predated any of these advents. And so the ability for criminals to access web-based digital platforms to organize or conceal their activities is plaguing our environment. So I do want to acknowledge and then thank our Secretary of State Sahota, the Minister Anand Asagri, for their conversations. I have the advantage of being on the Canadian Association of Chiefs Board of Directors. President Tom Creek of the OPP was able to be there for the announcement yesterday, Chief Myron Demke, another board member, but also on behalf of the Ontario Association of Chiefs of Police, President Mark Campbell, who unfortunately couldn't be here today, has been advocating for decades for this. And I think Commissioner Creek, rightfully so, indicated that the last time was in the late 90s that we had begun asking for these changes to occur. And to see it evolve to this day is very critical. Can I tell you, today is not about the policing story. You do have some of our community partners that see victimization every day. I'm pleased to have Sylvia here from Peel Children's Aid Society, as well as Sarah Rogers from our Victim Services Appeal. Do you know, if you were the recipient of an online threat, a hate crime, in Peel, we're the forefront of extortions, it could take us up to 30 to 40 days, if not 60 days, to find out who sent you a WhatsApp message to threaten you. In almost all of our international partners that are also responding to victims, they can get that data within 30 minutes, 2 hours, days. But here in Canada, for the longest time, we've had to wait months for that. And that is based on a regulatory framework, which we're now seeing the changes to that. And the legislation is one part of it, but it in fact affects our ability to investigate child exploitation, hate crimes. I talked to you about human trafficking, organized crime, and every aspect of it. What it does allow us to do is give us clear pathways with guardrails through proper judicial authorization to be able to access information. It establishes thresholds that allow us to obtain information, production orders, to allow police to confirm where people's data is housed, to identify suspects and advance investigations in a way that we cannot and have not been able to do in a timely fashion. I do want to reiterate what Secretary of State Sahota acknowledged, and I need to say that it has been misinformed in the public's eye. What C-22 doesn't do, it does not expand unchecked police authorities. Judicial authorization has always been the core to what we do. Privacy laws, the Charter, are core fundamental elements of law enforcement in Canada. And I can tell you, this country is proud to have some of the best police agencies and investigators, I can say, in our international standpoint, right here in our country. But what it does do is modernize our ability and strengthen public trust in the ability for us to respond to the crimes that cause the most frustration and harm in our communities. Why does it matter? It's inseparable. Our ability to investigate digital related crimes is a core ability of our community now. And so to not be able to investigate these elements in a fashion that prevents harm, modernizes our approach to responding to investigations and holding offenders accountable, this is a core element to it. If you were to tell me what is the biggest public safety issue for you, whether it be, repeat violent offenders, extortions, home invasions, auto thefts, in a world of geopolitical issues, hate crime, international, transnational issues, this bill is a core foundational element for our ability to respond to all of that. So in closing, and our job in policing is to work with all levels of government. I do want to reiterate our view from the Canadian Association of Chiefs of Police, from the Ontario Association of Chiefs of Police, right here at Peel Regional Police, Deputy Milinovich, who's done a remarkable job working behind the scenes with government and all stakeholders. This is a nonpartisan issue. It is a public safety issue. And police leaders across Canada, right here in Peel, support Bill C-22. And I want to thank the federal government for seeing this through difficult discussions and doing the right thing for everything. Critical digital evidence is a core foundational element of our ability to keep all of you safe. So thank you again for the opportunity to be here, and we look forward to seeing the outcome of this.